Good morning, everybody. And welcome to the second session of our summer lecture series, whose theme is Critical Thinking for the Preservation of Democracy. Today's session is on gun rights. And you may have noticed additional cameras here today. That's because C-SPAN is recording this session, and they will be broadcasting it later this summer or early fall. We don't know when, but of course you're here, so you don't have to watch it on TV when it comes out. We are also live streaming again, as we are going to all summer, to other OSHA programs at the University of Kentucky, the University of Georgia, UMass Boston, Granite State College, and the University of Vermont in Burlington. Please remember to silence or turn off your cell phones or other devices. And if you have to leave anytime during the session, please exit to the rear. And we will have a 30-minute break today and ask you to bring your questions down right at the break. Last week, we had a lot of people bringing questions down near the end of the break, and that's too late for us because we get a lot of questions, and we want to make sure we get the frequently asked questions to be asked of the speakers, and we put them in an order. So when you bring them down near the end of the break, we don't have time to sort through them. So please bring them down right at the break so that we can deal with them. So let's thank our underwriters, the Jack and Dorothy Byrne Foundation, Caldwell Law, Dartmouth 250, Dartmouth Coach, Kendall at Hanover, Ledger Financial Advisors, and Wells Fargo. So let me now introduce our speakers and our moderator. Joseph Blocher is a professor at the Duke University School of Law. His principal interests include federal and state constitutional law, First and Second Amendments, and legal history. Joseph earned his BA degree, magna cum laude, from Rice University, a master's degree from Cambridge, and a JD degree from Yale School. And by the way, he knew both of the people we had last week, although he didn't take any courses from them. Joseph helped the briefing for the landmark Supreme Court District of Columbia versus Heller in 2008. The District of Columbia Firearms Control Regulation Act of 1975 required, among other things, that all firearms be kept, quote, unloaded and disassembled or bound by a trigger lock, unquote. It also restricted residents from owning handguns except those registered prior to the enactment of the law. In a 5-4 decision, the Supreme Court said that the Second Amendment protects an individual's right to possess a firearm unconnected with service in a militia, and to use that arm for traditionally normal purposes such as self-defense within a home. Unfortunately, Joseph was on the wrong side of that decision. Our second speaker is Erin Murphy. Erin Murphy is a partner and litigator with the Washington, D.C. law firm Kirkland & Ellis. She earned a BA degree from Northwestern University and a JD degree, magna cum laude, from Georgetown University Law Center. Erin is clerked for Chief Justice John Roberts and has argued 4 cases before the Supreme Court. In her first Supreme Court case, McCutcheon versus FEC, the campaign finance case brought by the Republican National Committee challenging individual aggregate campaign finance limits, Erin won. She has also argued several cases before the Federal Appeals Court. In one, she challenged the city of Sunnyvale, California, in a Second Amendment challenge. In this case, the Ninth U.S. Circuit Court of Appeals upheld the city of Sunnyvale's law restricting the high-capacity gun magazines. It rejected arguments of groups such as the National Rifle Association, which contended the restrictions are unconstitutional and undermine the owner's right to protect their homes, as was established in the 2008 Heller versus D.C. case. That case has now been usurped from a California law, but that still hasn't been fully decided. Our moderator today is John Garvey. John is a professor at the Franklin Pierce School of Law at the University of New Hampshire. He earned an AB degree from Harvard and a JD degree from Suffolk University. He is also a mediator and arbitrator and was selected by his peers as Mediator of the Year in both 2014 and 2017. John is the founding director of the nationally acclaimed Daniel Webster Scholar Honors Program, a collaboration between the UNH School of Law, the New Hampshire Supreme Court, and the New Hampshire Bar Association. Students are accepted into this program prior to their second year of law school and discover firsthand what it takes to succeed in today's legal marketplace. They hone their skills in both simulated and real settings, counseling clients, working with practicing lawyers, taking depositions, appearing before judges, etc. Students pass a variant of the New Hampshire Bar exam during their last 2 years and are sworn into the New Hampshire Bar the day before graduation. So let me ask that our speakers and moderator come on stage.
Good morning. It's so nice to see all of you here for this debate. As you know, we have two very distinguished lawyers who participate at the highest levels when it comes to interpreting the Second Amendment. In fact, they have both recently filed briefs, as you heard, with the Supreme Court in a case that raises this very topic. Today, they're going to debate the issue of how courts should go about interpreting the Second Amendment with respect to the individual right to keep and bear arms, a right which was confirmed by the Supreme Court as recently as 2008. This will be a constitutional debate rather than a public policy debate. The so-called gun debate has become so prominent in the United States that many people probably assume the issue has been raging since the birth of our nation. In fact, until the 1960s, the Second Amendment was barely discussed in the courts at all. So let me give you a brief overview to sort of set the tone for what they're going to be speaking about today. In the 1960s, Bobby Seale and Huey Newton started the Black Panthers in Oakland, California. Huey Newton had some legal training and took the position that the Second Amendment gave individuals the right to bear arms in public, which they and their fellow Black Panthers began to do. This created a stir, to say the least, and shortly thereafter, the California legislature passed a law restricting the possession and use of weapons in public places. Federal restrictions and new laws in other states soon followed, and this energized some gun owners and libertarians who felt that the government was infringing on their constitutional rights. And as you know, the NRA became quite vocal, particularly since the 1970s. When the gun debate began, the major debate was whether the Second Amendment is limited to militia-related people, arms, and activities, or whether, as the Black Panthers and the NRA claimed, it includes an individual right to keep and bear arms, disconnected from any actual or potential service in an organized militia. This question was answered by the Supreme Court in 2008 in the case you've heard referred to called the District of Columbia versus Heller. The Supreme Court held that the Second Amendment does include an individual right, at least to the extent of keeping and using handguns in the home. So the Second Amendment is not limited to the organized militia. But Heller also makes it clear that gun control is not categorically unconstitutional. So another thing we know is that the right to keep and bear arms, like all other things, like all other rights, is subject to regulation. Having said there's an individual right, Justice Scalia's majority opinion went on to say, nothing in our opinion should be taken to cast doubt on long-standing prohibitions on the possession of firearms by felons and the mentally ill, or laws forbidding the carrying of firearms in sensitive places, such as schools and government buildings, or laws imposing conditions on the commercial sale of arms. With the individual rights reading resolved, the question for the Second Amendment now, as for most constitutional rights, is what kind of regulations are permissible. Over the past 10 years and in more than 1,000 cases, that has been the question that courts have struggled to answer. Until recently, the Supreme Court has stayed out of that debate, though, as we'll talk about, the justices have agreed to hear a New York case that has the potential to change everything. And that is the case most recently, which our speakers have filed briefs in. Aaron Murphy is counsel for the petitioners in that case. Joseph Blocher has filed a friend of the court brief in support of neither side. But before we get into the details of that, I'd like to start with the broader question for both Aaron and Joseph. The Supreme Court has said that the Second Amendment includes an individual right, but it is not unqualified and some restrictions are permissible. Given that, how should courts determine which gun regulations are constitutional? Aaron?
Good morning, and thank you for having me here. It's great to be in this area. I haven't been up to this part of the country before, and given the position that I will be taking in discussing these issues, it's a delight to be in a state that actually continues to respect and protect Second Amendment rights. That's something we're always looking for in all of these cases in all of these states where I litigate. As John mentioned, I've been involved in many cases, and many of the cases that we'll talk about today have litigated these cases typically on the side, always actually in all the cases I've been involved in, on the side of advocating in favor of Second Amendment rights and challenging restrictions that have been passed by states, municipalities, and in a few cases, the United States. And it's been a really interesting and so far kind of certainly a challenging area to litigate over the past 10 years because we've seen so many jurisdictions that continue to pass extremely aggressive laws that really don't seem consistent with the notion that the Supreme Court has recognized that the Second Amendment is an individual and fundamental constitutional right. Now, that's certainly not true of all jurisdictions. Actually, most states, well over 80% of the states, protect the right not just to possess a firearm in the home, but also to carry a right. Many states through carry a firearm. Many states through licensing regimes known as kind of shall issue licensing regimes, where basically any law-abiding citizen is going to be able to obtain a right to carry a firearm. So most of the states in the country have been protective and continue to be protective of the right that the Second Amendment protects. But notwithstanding the fact that it's been 10 years since the Supreme Court said that this is in fact an individual right, we continue to see a small number of jurisdictions, and unfortunately jurisdictions that have an extremely large populations, so make up for a large portion of the country, even though there are a smaller number of jurisdictions, that have responded to Heller by, instead of ensuring protection of Second Amendment rights, actually passing ever increasingly more aggressive and constraining restrictions on the rights to keep and bear arms. One great example of this has been the city of Chicago. If you go back to the Heller case itself, Heller was about whether you can have a ban on the possession of handguns, and the Supreme Court held that the District of Columbia's ban on possession of handguns was unconstitutional. Chicago had in place a nearly identical ban on the possession of handguns. Instead of acknowledging that under Heller its ban was clearly now unconstitutional, Chicago continued to defend it. And Chicago continued to defend it by arguing that the Second Amendment doesn't apply at all to states and municipalities. Now, pretty much every other individual constitutional right, whether actually enumerated in the Bill of Rights or recognized by the courts through other doctrines like due process, has been interpreted for decades to apply not just to the federal government, but to states and municipalities. Yet Chicago and a few other jurisdictions refused to acknowledge that they were even bound at all by the Supreme Court's decision in Heller, and that the Second Amendment has any impact on states and municipalities. And that was the position that led the Supreme Court to its second decision, which is also at this point nearly 10 decades old in this area, the McDonald versus City of Chicago case, in which the court rejected that position and said, no, this is an individual fundamental right, and states and municipalities must respect it the same way that the federal government was. But even then, Chicago would not give up. Chicago responded to that decision within a few days by passing an extremely aggressive system of licensing regime for possessing a firearm. And under that regime, Chicago said that in order to get a license to possess a firearm, you had to have had an hour of training at a firing range. Okay, so far so good. You know, we all agree it's absolutely important to understand how to use your firearm if you're going to possess one. But at the same time, Chicago then simultaneously prohibited firing ranges within the city of Chicago, thereby making it illegal, basically impossible for its own residents to actually obtain what Chicago had said they needed to have in order to qualify under Chicago law to have a firearm. That was struck down, and the city of Chicago nonetheless continued to have aggressive laws. It was one of the first jurisdictions to have a complete, absolute prohibition on carrying a firearm, which was held constitutional, and it continues to have extremely aggressive restrictions today, including being among the jurisdictions that imposes just a special discriminatory tax on firearms, on obtaining a firearm. Now, the Supreme Court has said for decades that you can't impose special taxes on the exercise of a constitutional right. Sure, if you have just kind of a general tax that applies to everything and incidentally reaches a constitutional right, then the tax can apply there too. But the Supreme Court has long made clear when it comes to the exercise of First Amendment rights, speech, the exercise of freedom of religion, all these other areas, the court has said, no, you can't have a special tax that singles out the exercise of constitutional rights, because that's really trying to deter people from exercising rights that they possess. Yet Chicago and a couple of other jurisdictions continue to have exactly that, special taxes that they impose, really pretty much for the acknowledged purpose of just trying to deter people from exercising a right that the Supreme Court has held the Constitution protects. We've seen the same thing from other jurisdictions, really aggressive laws from places like San Francisco, LA, the District of Columbia. New York and New York City have been particularly aggressive, and it's a New York City restriction that has led to the Supreme Court deciding to hear a case this fall that will mark the first case in about 10 years that the Supreme Court has heard in this area. New York City has a restriction. They have a licensing regime that says that in order to possess a firearm within your own home, you have to obtain a license that's known as a premises license. And as a condition on that license, it says that you cannot remove the firearm from your home to take it anywhere except to an authorized shooting range. And even then, you have to transport it unloaded and locked up in a container, locked separate from its ammunition. But the catch beyond even that is New York City defines authorized to include only shooting ranges within the boundaries of New York City itself. There are a grand total of 7 shooting ranges in the entire city of New York, a city of more than 8 million people. And this results in a restriction that you cannot remove a handgun from the limits of the city of New York at all. This is an outlier restriction that we have to this point found no other jurisdiction in the entire country, city or state, that has. There's no one else that says you cannot remove your firearm from the limits of this city at all, even to just take it next door to a shooting range that may be, 15 minutes away if you're talking about someone who lives at the edge of New York City and wants to go, say, into New Jersey or out to Long Island. So these are the kind of restrictions we can continue to see from jurisdictions that really don't want to accept the proposition that this is a fundamental individual right, and instead continue to treat the right to keep and bear arms as if it were really more of a privilege that people are allowed to exercise only at the grace of the state and with the state's permission and with all of the constraints that the state wants to put on it. Now, many of these restrictions have been challenged in courts, and normally, when you're dealing with the realm of restrictions on the exercise of constitutional rights, the basic rule is those restrictions are presumptively unconstitutional. Yes, it is not the case that you can't regulate constitutional rights at all. You can have laws that pass muster that impede in some respects on First Amendment rights and other rights, but generally when you go to the courts treat those laws as presumptively unconstitutional, and it's the government's burden to explain how they can be consistent with and don't unduly restrict the exercise of constitutional rights. Yet in this realm, what we continue to see from the lower courts is that the lower courts aren't particularly interested in figuring out what the right protects. They're instead really fixated on that language that was mentioned at the outset here from Heller that said not every law is unconstitutional in this area. And essentially what they do is kind of treat that as the holding of Heller. That it's as if instead of holding that Heller protects a constitutional right, what Heller really said is, don't worry, you don't really have to protect this right. And so we see courts adopting extremely broad positions about kind of categorical types of laws that they consider not subject to any degree of scrutiny by courts at all. And a couple of examples I'll give you. So if you go back to that language that was mentioned earlier from Heller, what Heller said is, nothing in our opinion should be taken to cast doubt on longstanding prohibitions on the possession of firearms by felons and the mentally ill, or laws forbidding the carrying of firearms in sensitive places such as schools and government buildings, or laws imposing conditions on the commercial sale of arms. So you've got kind of three types of laws that the court talked about that it said were presumptively, it didn't even say necessarily, but presumptively constitutional. Taking from that language, the District of Columbia enacted essentially a ban on carrying firearms and argued that the entire District of Columbia is a sensitive place, akin to a school or government building, that the whole district is an area to which the Second Amendment does not apply. And one of the judges that they argued that position before agreed and said, it appears to me that the District of Columbia is essentially one big government building, and so the Second Amendment kind of doesn't really apply here. Now this is particularly remarkable given that if you go back to Heller, I mean, the jurisdiction in Heller was the District of Columbia, and the District of Columbia argued in Heller that it was not bound by the Second Amendment, and the Supreme Court disagreed. Yet the district has continued to argue that it remains not bound by the Second Amendment, and there are judges that have agreed with that position and have embraced that position broadly in other jurisdictions as well, essentially concluding that entire cities can be deemed sensitive places. We litigated a case a few years ago in California that involved special restrictions, fees that California puts on the ability to engage in a firearms transaction. They basically have a fee that you have to pay that then they put into an account that they use to go engage in law enforcement activities against people who unlawfully use firearms. So they basically make it a condition of obtaining a firearm as a law-abiding citizen that you help pay for special costs generated by citizens who violate the law. When we challenged that provision, the district court that we started before, invoking the language from Heller that talked about laws imposing conditions on the commercial arms of sale of arms, said that all commercial restrictions having anything to do with firearms are categorically outside the scope of the amendment, such that they are just ipso facto constitutional, and courts don't need to look at all at the impact that they have on Second Amendment rights. As we explained to the courts in challenging that, if that were correct, it would mean that a jurisdiction could impose a $1 million fee as a condition of obtaining a firearm, and the Second Amendment would have nothing to say about it. That's an extraordinary proposition that no court would accept if we were talking about First Amendment rights. In the First Amendment area, it's quite clear and has been for quite some time that, as the court put it in one opinion, a tax of even a halfpenny on the exercise of First Amendment rights can be unconstitutional. Yet here we have courts saying that there is no scrutiny at all, no room for courts to even analyze conditions on the sale of firearms. And in our New York case, the one that's going to the Supreme Court this fall, when we challenged this restriction on the ability to remove a firearm from the limits of New York City and take it to a shooting range next door or participate in a target shooting competition in a neighboring state, the court that we challenged that before refused to accept the proposition that the Second Amendment includes a right to learn how to actually use your firearm. The court assumed without deciding that perhaps Perhaps the Second Amendment would include the right to actually know how to use your firearm for self-defense rather than just keep it in your home with no idea what to do with it. But they wouldn't even accept the notion that that was clearly something that's within the scope of the Second Amendment. All of this pattern of activity, both from jurisdictions and from the courts, has led several justices on the Supreme Court to observe that really there seems to be a consistent and persistent pattern of treating this right as a second-class right, as sort of the stepchild of rights, as one justice has put it, as a disfavored right, as Justice Thomas has put it. And justices have repeatedly said, and Justice Alito, who authored the opinion back in McDonnell itself, said, that you can't treat a constitutionally enumerated right as somehow lesser and entitled to lesser protection than other rights in the Constitution. But yet this is time and again what we see. Basically what there seems to be is this pattern of resistance to courts and jurisdictions that don't like the idea that the Constitution protects this right, and therefore they're not willing to give it the same respect and treat it the same way that they would treat another constitutional right. We would submit that's just not a permissible way to go about interpreting and applying the Constitution. When we have a Constitution that establishes rights, it's the obligation of jurisdictions to protect them, and it is the obligation of courts to enforce those rights and strike down laws that infringe on those rights. So I would submit that it would be, that all of these courts and all of these jurisdictions would be much better served by spending some real time focusing on the 60-some pages of the Heller decision that explain what are the contours of this right, that explain what it is they're supposed to be protecting, rather than fixating on this single line of dicta from the court in which they simply made the unremarkable observation that just as with any other right, not every single law that has anything to do with the Second Amendment is unconstitutional. In fact, the way that courts should be looking at this is the same way they look at rights in other contexts and say when a state wants to pass a regulation that impedes Second Amendment rights, just as in the area of First Amendment rights, they start with a presumption of unconstitutionality, and it is the obligation of the state to prove to the court that what it has done is engage in regulation that is consistent with the scope of the right that the Constitution protects.
Good morning. I'd like to begin by thanking Pete and John for that incredibly generous introduction, Osher and the organizers for putting together this fantastic lecture series, and all of you for being here with us this morning. It is a real honor and a privilege for us to have a chance to discuss and debate these incredibly pressing and complex issues with all of you, and for me, a particular thrill to have a chance to do it with Aaron Murphy, who, as Pete's introduction suggested, has really been at the forefront of some of the most important Second Amendment litigation in the country over the past few years. Aaron and I come at this issue from different perspectives in a few ways. One is that I'm a law professor by trade, not primarily an advocate, so I'm going to focus more what I see as the broad trends and less on specific cases. I think actually that Aaron and I have some common ground. There are principles, large principles that we agree on, and that to the degree that we part ways, it has largely to do with how those principles apply in practice. So I thought maybe I would start by just clarifying, based on her opening remarks, what I see as our areas of agreement and disagreement. First, I emphatically believe that courts, and I would add scholars, politicians, the general public, have to take the Second Amendment seriously. I think that to the degree that we may part ways, it's about what that means in practice, what it entails to take the Second Amendment seriously. I also think that part of taking the Second Amendment seriously is taking seriously the Supreme Court's decision in the District of Columbia versus Heller case. Now, as Pete mentioned in his introduction, I was on the losing side of that case, so I'm not the most natural candidate maybe to be up here celebrating its legacy or defending it as precedent. And to be clear, I have some qualms and criticisms with the way that opinion was reasoned and to some extent with its result. But I've also written, and will emphasize here again today, that it is the law of the land, and it seems to be doctrinally secure, and that any effort to answer the question we've given ourselves today, which is how should courts interpret the Second Amendment, has to build on the foundations that Heller laid down. But that's not necessarily bad news for those of us, and here I certainly include myself, who support reasonable gun regulations. And it may be here that Aaron and I start to part ways, at least in terms of what we emphasize from the Heller decision. It's absolutely true, and this alone makes it a landmark decision, that the Supreme Court in Heller recognized, really for the first time, the individual right under the Second Amendment to keep and bear arms for certain private purposes disconnected from service in an organized militia. And they make clear that the central component of that right is self-defense in the home. But that's not all that the court did. And you've heard this already from Pete and John and Aaron, but it's worth emphasizing that the court says that right, like all constitutional rights, is subject to regulation. And Aaron is absolutely right, and I agree that that should be an unremarkable proposition. That is true of every other constitutional right that you have, free speech, free exercise of religion, and so on. But I actually think it is worth emphasizing because too often in the gun debate, you hear people say things like, I oppose gun control because I support the Second Amendment, or vice versa. And that's just a false choice. That's a false dichotomy. Rights and regulation can coexist and have coexisted since the beginning, since the founding of this country and even before. And in fact, Justice Scalia's majority opinion emphasizes that. You've already heard this language a few times, but it's again worth reflecting on, I think, that he says in the majority opinion, nothing in our opinion should be taken to cast doubt on longstanding prohibitions on possession by felons and the mentally ill or the carrying of weapons in sensitive places like schools and government buildings, restrictions on the commercial sale of arms. I would add to that list, elsewhere in the opinion, he points to bans on dangerous and unusual weapons, bans on concealed carrying. And I think part of taking the Second Amendment seriously and taking Heller seriously is acknowledging and thinking seriously about its boundaries, about its limitations. This is not an unlimited right. It doesn't cover all forms of guns or gun-related activity or even all people. And even in the area that it does cover, it is not immune to prohibition. And again, that doesn't make it different than any other constitutional right. There are some forms of speech, whether it's perjury or libel or securities fraud, that just don't even trigger the protection of the First Amendment. They simply fall outside constitutional protection. And the reason that's significant is that those categories that Justice Scalia enumerated in practice describe an awful lot of the gun regulation that we have in the United States today. I mean, Aaron and I will probably focus our disagreement with regard to particular cases on a certain subset of outliers that involve unique laws or at least outlier laws, like the New York law that Aaron mentioned, which as far as either of us can tell is unique, and that New York itself has disclaimed any interest in defending. But I think it's important to keep in mind, too, the forest that lays behind those trees. Since Heller was decided 11 years ago, lower courts have resolved more than 1,000 Second Amendment cases. It's actually probably closer to 1,500 now. And the vast majority of those are not close cases. In more than 90% of them, the courts have rejected Second Amendment claims. And that's not necessarily because they're biased against them. It's largely because a lot of those claims are weak to begin with. Nearly a quarter of them involve felons trying to get out from behind the federal law which prohibits convicted felons from having guns. Again, Heller says specifically that that law is constitutional. It's supported by history and common sense. 99% of those cases are losers. And again, I think it's important when we're trying to answer the question, what is the test we should be applying across all the cases, to keep the broad view and not set heightened scrutiny or strict scrutiny across the board just on the basis of a few of these outlier cases. We don't need to burn down the forest when all we need to do is trim a few bushes. I think it's also important to remember what motivates these laws. And in my experience, at least, it's not bias against the right to keep and bear arms or against gun owners. I think that And polls show most Americans support both the individual right to keep and bear arms and reasonable gun regulation. Right? They recognize what the constitutional law says, which is that rights and regulation can coexist. And that to the extent people support regulation, I think it's because they are probably stunned by the fact that still today, every year, 100,000 Americans are shot. 30,000, last year almost 40,000 Americans die as a result of gunshots. Now, some of those are self-inflicted, some of those are people being shot by others, some of those people being shot on purpose, sometimes people being shot by accident. I should note, by the way, that the majority of gun deaths are suicide deaths. But what that means is that I think any effort to make a dent in this massive problem that everybody recognizes is a problem is going to require some flexibility. Sometimes we talk about gun control as if it's just one thing. And it is not remotely, practically, politically, or constitutionally feasible to think about it that way. There is no even remotely plausible proposal to take away the 200 or 300 million guns in circulation in the United States. The question has to do with particular policies, like denying guns to people convicted of a domestic violence misdemeanor, or under a restraining order, or suffering from a drug addiction. Right? Those are the kind of tailored policies we're going to need that marginally, even if they make 1% of a difference, could mean saving 1,000 people from being shot or 300 people from dying every year. That's the kind of flexibility and tailoring that we're going to need, and it may lead to different solutions in different places. What's appropriate or necessary in a place like Manhattan might not be appropriate or necessary in a place like Hanover, or for that matter, over in Rutland. And I think what we're seeing are communities and states playing their constitutional role as what Justice Brandeis called laboratories of experimentation and trying to find the solutions that work for them. And again, those answers are going to vary from place to place. What that means from constitutional law, I think, is that the unconstitutional laws, the outliers that go too far, and Aaron mentioned a few of them, have to be struck down. You don't get an exception to the Second Amendment just for being well-intentioned. But when the cases are close, when the precedent isn't clear, when the history isn't clear, when the empirics are contested, we should be cautious, I think, about adopting a rigid nationwide rule that might prevent communities from finding those solutions. And I think, fortunately, so far, that's basically the route that courts are taking. And they're doing so by applying what's generally called a two-part test. The first part of that test asks whether the challenged law in any way reaches guns or gun-related activity or people who are covered by the Second Amendment. And as we've said, some aren't, right? Felons, dangerous and unusual weapons, sensitive places, those are just, from most courts' view, carved out from Second Amendment coverage, just like some forms of speech are carved out from the First Amendment. Right? They don't trigger any Second Amendment analysis. That's sufficient to resolve hundreds of cases. For those that are, courts go on to the second step and ask whether the law is justifiable in light of the burdens that it places on individual rights holders. Again, even constitutionally protected conduct can sometimes be regulated. Even political speech can be regulated if the government can show, again, a sufficient reason and that the law is sufficiently tailored to serving that purpose. And here, because the laws are so diverse, it's a little harder to generalize about the approach that courts are taking, but I think that overall, it looks a little bit like a sliding scale. So that the higher the burden on the individual rights holder, the more the law entrenches on that core interest of self-defense, especially in the home, the higher the burden on the government to justify what it's doing. Conversely, when you have a law that does not entrench on that core interest of self-defense in the home, it's easier for the government to justify its position. And again, that's settled common ground. It's a test almost universally adopted across the federal courts. And so in some respects, I guess what I'm presenting here is something of a conservative argument against a potentially radical change. And there is a potentially radical change, an alternative test which has been articulated, I think, in some prominent dissents in the courts of appeals, including by then Judge, now Justice Brett Kavanaugh. And the way this approach would work is one would evaluate the constitutionality of a gun regulation based solely on reference to text, history, and tradition. I think that adopting this test by itself would be a mistake, and I want to be clear about why. I think text, history, and tradition are very important to interpreting the Second Amendment, just as they are important to interpreting any other constitutional provision or answering any other constitutional question. We always begin with the text. History and tradition should always matter. The problem is that text, history, and tradition alone are unlikely to give satisfactory or useful answers in hard cases and might actually open the door to a lot of unarticulated judicial power and judicial discretion. I should also say that the test of text, history, and tradition would not necessarily enforce gun rights any more powerfully than the typical forms of heightened scrutiny that we apply to other constitutional rights. And Judge Kavanaugh rightly emphasized this in his opinion. People sometimes underestimate the degree to which we have had gun regulations in this country since the founding. I mean, even before the founding, go back to the Statute of Northampton in England in the early 1300s, right through Blackstone, through the colonial era. We had in the colonial period here in the Northeast laws that effectively banned people from having loaded guns in urban areas. Places like Philadelphia, Boston, New York had extremely stringent gun laws, and those traveled with the country as it expanded west. Places like Dodge City and Tombstone, Arizona, those famous gun havens, made it illegal to carry your gun in city limits. So gun regulation is nothing new in the United States, and a properly applied test of text, history, and tradition could end up upholding a lot of gun laws. So my opposition to this test, to be clear, is not because I think text, history, and tradition are irrelevant. I think they're very relevant. Nor is it that the test, if properly applied, would be too stringent. I don't think it would. I think the problem is that it just won't give satisfactory answers in the kinds of hard cases that the courts are going to have to confront. The Second Amendment is 27 words long, and nothing in those words tells you whether a machine gun is an arm protected by the Second Amendment. Nothing in it tells you whether a person under a domestic violence restraining order is among the people protected by the amendment. You might turn to history and tradition for some guidance, but sometimes they too are silent or sometimes conflicting. I mean, Heller is a good example of this. 9 justices, all of them brilliant, none of them historians, all of them brilliant, doing their best with the history, look at some of the same sources and come to radically different conclusions. That's the same problem you run into if you ask historical questions about particular kinds of gun laws, like restrictions on public carry, where you'll find different answers depending on where you ask the question. Up here in New England, especially in urban areas, there was a tradition of regulating public carry much more stringent than there was in the South. But the South led the way in restricting concealed carry. How is a judge supposed to choose between these two different threads of American history? They're not numbers that can be averaged together. And then, of course, there's the just obvious sort of practical problem of drawing useful comparisons from the late 1700s or the mid-1800s to today, especially with regard to a rapidly changing technology like guns. Now, some judges have tried to do this by trying to identify the lineal descendants of guns from the late 1700s to today, or the lineal descendants of gun regulations. But that's a very hard thing to do. You know, judges are not historians, and guns don't have progeny, or they don't have family trees. In what way is an AR-15 a descendant of a musket? I mean, do you look to their barrel lengths, to how many shots per minute, to the muzzle velocity? Those are hard questions. And I think that in practice what we will see is that judges are going to answer them, and again, Judge Kavanaugh says this, by analogy. And there's nothing necessarily wrong with that. We reason by analogy all the time. To analogize is to find relevant similarities between two things. But that puts a lot of weight on what judges see as relevant similarities. Right? Maybe their views look like yours, but maybe they don't. Maybe their intuitions are the same as yours, maybe they're not. Maybe they are protective of gun rights, but maybe they're not. But I think that there's reason to be skeptical of a test that says it's based on text, history, and tradition, but I think will probably boil down to a test of judicial intuition or judicial analogy. You can illustrate this just with any number of hypotheticals or examples. Ask whether, for example, a modern grenade launcher is like a musket from the late 1700s. In some ways it is, because you can lift it. It's a bearable arm, and that would suggest that it is covered by the Second Amendment. You might say, well, that can't be right. It's more analogous to a cannon because of its destructive power and therefore not covered by the Second Amendment. I don't think that's a good way to chart. I mean, debating those positions is not a good way to chart where our constitutional law could go. Because what matters, I think, both to gun owners and to regulators is the functionality of the arms at issue. What we care about is whether a particular law functionally interferes, materially interferes with people's ability to exercise their constitutional right to armed self-defense, especially in the home. So the questions we should be asking aren't whether an AR-15 is like or unlike a musket from the late 1700s. We should be asking if the government bars people from buying AR-15s but allows them to buy certain other kinds of weapons, does that materially interfere with people's ability to defend themselves in their homes? If so, has the government shown a good enough reason and that the law is tailored to furthering that reason? Those strike me as more traditional legal questions, the kinds of questions that a judge might answer. But let me say just quickly in closing, too, that as Aaron and John emphasized, we're here talking about the constitutional law and the Second Amendment sort of in particular. But the Second Amendment is not the major obstacle to further gun regulation in this country. And supporters of reasonable gun regulation are not, as Aaron said, losing a ton of cases in the courts. The primary obstacle to further gun regulation is political. The Second Amendment, and again, Aaron and I agree on this, so I'll end on something we agree about. The Second Amendment preserves some space for regulation, and it's a question of politics, how we want to fill or not fill that space. And there have recently been strong pushes for certain gun regulations in certain parts of the country. The post-Parkland movement is a good example of this. Young people say prevention of gun violence is a top priority for them. And my argument, I guess, is that the Second Amendment, properly interpreted and as interpreted so far, allows us to make those choices. Thank you very much.
Thank you, Aaron, and thank you, Joseph. I have some questions for you in follow-up. As lawyers, we're very familiar with different burdens of proof. We look to reasonable doubt. We look to more probable than not. And we know as lawyers that depending on the burden of proof, our case may be harder or easier. Do we agree? Okay.
We do.
So I understand I have read your briefs in the New York case that we've been discussing. And Aaron, I understand that you disagree with the two-part test. Is that correct?
Well, it's probably a little bit more nuanced than that. But, I think our principal problem is with the way this test has been employed and the execution of it by the lower courts. In the abstract, the test seems innocuous. You start by asking kind of whether what is being regulated is within the scope of the right. And then based on that, you decide on the level of scrutiny, sort of this burden of proof question. The problem we see is if you look at courts, if you take the first part of the test, there are numerous courts that have, when asking that question of whether something comes within the scope of the right, say, well, Heller had to do with handguns in the home, so that's the full scope of the right. Full stop. We're not interested in whether there's anything else out there unless and until the Supreme Court tells us that something else is within the scope of the right. We will assume nothing else is, whether it is, something other than a handgun, whether it's having a handgun outside the home, whether it's taking it to a firing range. So you can't really have a test that it purports to ask about the scope of the right, but then engages in no actual meaningful analysis of the scope of the right. And I think one of the best illustrations of this is, the vast majority of kind of the most significant cases that have dealt with Second Amendment challenges, not kind of the ones that everybody agrees where you have a lot of kind of criminals raising arguments that people don't think are viable arguments, but the ones that really deal with the outlier laws, you have courts just assume without deciding the answer to the question of what the scope of the right is. And I think it's extremely problematic to start a constitutional analysis by not even answering the question of what the scope of the constitutional right is. So I think that's the first problem with it. I think the second problem that then Judge Kavanaugh was pointing out is when you get to this, after that, once they've kind of assumed without deciding that there's maybe something that's within the right, they ask what level of scrutiny do we want to apply? How heavy of a burden do we want to impose on the government? And in every single case, they apply the least kind of heightened rationale, if even that. Sometimes they just apply the lowest rationale possible. There's no case in which the court has ever concluded that it will apply strict scrutiny, which is presumptively the form of scrutiny that applies when any other individual right is at stake. Instead, they inevitably say, and typically what they say is, we'll assume without deciding that we'll even apply intermediate scrutiny as opposed to applying essentially no scrutiny at all. And so what you have is, in theory, a test that sounds like it's asking the right questions. What's the scope of the right, and how significant is this burden? But instead what you see are the courts time and again saying, we don't really care what the scope of the right is, and we don't really think anything burdens this right, as so long as you still have what Heller promised you, some ability to have a handgun in your home, nothing else is a meaningful burden on the exercise of the right. And if you kind of preordain the conclusions that way, then you've got a real problem with the test, because it's not being applied in a way that takes seriously the idea that you have to take the law before you and say, is this law consistent with the Constitution? Not, is this law identical to what the Supreme Court struck down in Heller?
Joseph, do you agree that the courts are treating the Second Amendment differently and or subjecting it to a second-class kind of status?
I think it's a hard question to answer in the abstract. Anytime you have a set of cases that is as large as we have in the sort of post-Heller Second Amendment world, more than 1,000, probably close to 1,500, there are going to be outliers on both sides. I think there are some cases, and I agree with Aaron on this, where courts have underprotected the right to keep and bear arms. I think that's unsurprising given the number of cases. I think there are other cases in which courts have erred in the other direction. I think my concern, and maybe my objection, is that is with labeling it a trend. I don't see a trend, and I think that the generalization is where I would push back. It's absolutely true there have been few successful Second Amendment challenges, but again, the reason for that, I think, has mostly to do with the fact that so many Second Amendment challenges, not the ones Aaron's describing, but the ones that actually form the bulk of the litigation, are weak to begin with. We shouldn't expect them to win. I said this earlier, that about a quarter of them are felons trying to get around the felon in possession prohibition of federal law. It's unsurprising that 99% of those cases, literally 99%, are losers, or that drags down the average of success. Most Second Amendment challenges are brought by criminal defendants who have every right and every incentive to bring any colorable claim they can, but they tend to lose their Second Amendment claims just like they tend to lose their other constitutional claims. A pretty big chunk of the set are pro se litigants. That's litigants without lawyers. And again, low success rate. When you put those together, it's no surprise, I think, that the overall success rate looks low, but that doesn't mean the right's being treated as second class. It just means that there's not necessarily a lot of strong claims being brought in the first place. I think one reason for that is that, and this is going back again to something Aaron said, is that in most parts of the country, there's not a lot of stringent gun regulation to challenge in the first place. This is not a target-rich environment for Second Amendment litigants. And so it'd be unlikely to see successful Second Amendment challenges, perhaps in a state like New Hampshire, which I gather has not stringent gun regulations. It's no secret that a lot of the cases come from states that are more prone to regulation, New York, California, and so on. But when you zoom in on particular classes of cases, you'll find a much higher success rate, and you'll find it in those courts, including the Second Circuit, the Fourth Circuit, the Ninth Circuit, and the D.C. Circuit, which are often tagged as sort of the more liberal circuits. That's actually where most of the successes have been. And I know this, and since I don't have cases, I have to plug my own scholarship here, because with my co-author, Eric Rubin, who's a Dartmouth grad, was very happy that I was going to be here today, and a team of researchers, we read and coded, that is, answered 100 questions about every single available post-Heller case from 2008 until 2016. So this is more than 1,000 Second Amendment challenges, which gave us a very broad view of what's really happening in the lower courts. And the data we got confirmed exactly that impression, that a lot of these cases are weak to begin with. When you focus on restrictions on public carry and you focus just on parties who are represented, the success rate goes way up, and it starts to look like it does for every other constitutional right. So I don't see the second-class treatment manifesting itself broadly in the courts. There may be cases, again, that have gone too far in deferring to the government, and where that happens, the Second Amendment stands as a limitation. But to generalize it as a way, I think, to change the way we treat all Second Amendment law would be a mistake.
If I could just jump in, just to be clear, I only litigate, I think I've almost only ever litigated civil cases. We are not bringing cases that are these cases you're referring to, and on the ground, I can certainly tell you, it is not the perspective that the meritorious, close call, tough cases that are challenging new novel restrictions as opposed to, cases being brought decades after the fact by people who were convicted a long time ago. These are not faring the way that they do if you're bringing a First Amendment challenge. I mean, I litigate a lot of cases out in the Ninth Circuit. Every time that you get any kind of victory in the Ninth Circuit, immediately, you start by arguing a case before a 3-judge panel. If you happen to get the rare 3-judge panel that actually rules in your favor, immediately some other member of the court will, if the parties don't do it, will spontaneously on their own call for the court to re-examine the case and have a new hearing to decide whether the panel must have been wrong to actually rule in favor of the party that was supporting Second Amendment rights. I had this happen in a case that we litigated against the state of California. It was in a preliminary stage, and we won an appeal on a very narrow ground involving a challenge to a magazine capacity ban. The court, on its own, a judge spontaneously said, we better re-examine this. And the state of California said, don't bother, please don't. And only after the state itself said, we don't even want you to re-examine this right now, did the court finally say, okay, I guess we'll leave this alone. But you just see this time and again with these cases. I mean, there are certain courts, and they are the courts that are dealing with the jurisdictions that are the most hostile in terms of passing the laws, that continuously seem to kind of just rubber stamp whatever it is that the states want to pass.
Aaron, if the Supreme Court accepts your position on how to review the rights guaranteed under the Constitution for the Second Amendment, do you feel that it's more likely that there will be successful challenges to regulation if they adopt the approach suggested by then Judge Kavanaugh?
Sure. And just to be clear, in the case, we haven't definitively kind of firmly advocated for a particular approach in terms of, we're happy to take then Judge Kavanaugh's approach. We're happy to take a meaningful, robust version of the two-part approach if it were really one in which the courts genuinely treated laws as presumptively unconstitutional. But one way or another, our principal point that we've been trying to make to the Supreme Court is whatever test it is that you're going to adopt in this area, first, it does need to take very seriously the history and tradition and look at this right the way that Heller did, asking what its scope is, what kind of things it protected back when the amendment was ratified, what the people understood it to be, and that if you do that, you will find that a lot of these restrictions are very inconsistent with the historical scope of the right. And so, we certainly do think that there are a number of laws that have been challenged, that courts have allowed to stand, that they should not allow to stand, and that they're only allowing because they're not applying the same kind of rigorous scrutiny that would be applied if you were dealing with rights under other provisions of the Constitution.
Heller involved the handgun, but you've both mentioned today that there are other types of weapons that would be subject to Supreme Court analysis, right? So how, this is a question for both of you, to what extent will the court figure out what kinds of weapons are protected by the Second Amendment?
Well, I think here, too, we can sort of lop off the extreme positions. I think it's clear that there are some kinds of weapons that can be regulated, even banned, without triggering Second Amendment scrutiny. Heller is clear about that. Common sense is clear about that. History is clear about that. It is also clear that there is at least one class of weapons, that being handguns, that cannot be banned, even if doing so would save lives. So I think we're kind of left with three categories. There's the ones that definitely can be banned, and the court in Heller seems to equate those with dangerous and unusual weapons, that being those not in common use. Then there's the ones that can't be banned, which Heller says is handguns, which Heller says are the quintessential self-defense weapon. And then there's that middle category of weapons, which are those that are not dangerous and unusual, which are in common use, which might be regulated if the government can show a good enough reason. And one class of weapons that's often litigated here, Aaron has litigated some of these cases, are the so-called assault weapons. And I say so-called just because the definition is sometimes hard to track down. People often mean different things when they talk about assault weapons. But in those kinds of regulations, I think that the relevant question, again, is what does that ban do to, if a jurisdiction were to ban assault weapons, what does that do to practically people's ability to effectuate their constitutional rights? I mean, to treat any particular class of arms as some kind of natural category that's immune to prohibition, I think is a mistake. That's not what Heller does. Heller says handguns are immune to bans because they are the quintessential self-defense weapon. Well, that means that AR-15s and the like are not the quintessential self-defense weapon. They shouldn't be treated exactly the same way. I think we have to treat these different classes of weapons differently. Now, in practice, a lot of this comes down to details. If you're regulating a high-capacity magazine ban, if you're passing a high-capacity magazine ban, what really counts as high capacity matters. Sometimes jurisdictions set that number quite low, and I think some of those have been struck down, I think probably rightly. If the number is 7, that's probably too low. But if it's 12 or 20, how much does it really impact people's ability to defend themselves in their homes if they can't have a 20-round clip? That doesn't seem to be, at least to me, a natural implication of Heller itself.
So I think it's important to go back to the way that Heller, it's always critical to put in context the language that people like to pull out of Heller in an effort to kind of support the gun regulation side of things. When Heller talked about handguns being the quintessential firearm and why they're the quintessential self-defense weapon and therefore within the scope of the Constitution, the court was saying that in the context of rejecting the argument that there's no need for people to have handguns so long as they can possess long guns. And what the court said was, no, that this isn't a right such that so long as you've got, some type of arm that's good enough and the state can kind of pick one and then you get nothing else. They said, yeah, even if you can have long guns, you have a constitutional right to handguns because they're a quintessential self-defense weapon that is commonly owned for the lawful purpose of self-defense. Now, what you then have is jurisdictions that turn around and say, oh, well, Heller said handguns are what's protected, so we don't have to worry about the rest of it now. And if you look at, drill down on some of these definitions of what it is that constitutes a so-called assault weapon and what it is that courts look at when trying to say that these weapons are somehow categorically different. I mean, essentially, it's just taking traditional rifles and having aspects of them that make them actually easier for someone to use for self-defense, make them safer for someone to use, and make them less likely to cause collateral damage if you do actually need to use them for self-defense purposes. Yet what you have are courts saying, oh, all of these things kind of make them, more effective and therefore more dangerous and therefore take them outside the scope of the Constitution. That's really quite a counterintuitive proposition if what you're thinking about is the notion of being able to own a particular firearm so that you can effectively use it if you actually were to need it for purposes of self-defense. So I do think the better way to come at this issue is the way that Heller itself did by saying, what kinds of firearms are traditional with the historical scope of what it is that we considered this right to protect, firearms that you use for self-defense, and if that's the kind of firearm that you're dealing with, then it's protected. And the state doesn't get to pick and choose, as the District of Columbia tried to do between long guns and handguns, as to kind of which protected firearms it actually wants to protect and which ones it doesn't.
Thank you both. I'd like to ask you one more question before the break, and it's to both of you. I'd like to ask whether and to what extent the right to keep and bear arms extends outside the home.
Sure, fully. So this has been an extremely hotly debated issue, and one of the biggest issues of litigation in the past kind of 5 to 10 years. As I mentioned earlier, there's, I believe at this point, it's 42 states that are right to carry states, but there are 8 states that have some version of kind of different types of restrictions. What we kind of tend to see most often today in those jurisdictions are what are known as kind of good cause regimes that say that you can get a license or permit to carry only upon a showing of good cause, which typically means that you have to demonstrate that you face an actual documented threat to your safety that differentiates you from ordinary individuals, law-abiding citizens, that you can come in with something like, hey, I've got a restraining order or somebody threatened me or things like that. So as a functional matter in those jurisdictions, really there is no right to carry for the ordinary law-abiding citizen. We have argued in all of these cases that those kind of functional bans are unconstitutional. If you look at the historical scope and the historical tradition of the Second Amendment. It has long been the tradition going back to the founding in the 1800s that there was a right to carry firearms. Certainly, as the court acknowledged in Heller, there can be, some restrictions, sensitive places, things and things like that. But these laws that just flat out essentially prohibit people from carrying firearms at all are really very just contrary to the history and scope of this right. And I think it's particularly problematic that you have a number of these courts have looked at this, and they've actually almost all either concluded or, as I suggested earlier, assumed without deciding that the Second Amendment does in fact protect a right to bear arms outside the home, not just to keep them inside the home. Yet they've nonetheless held these restrictions constitutional, which really makes very little sense to say that something is a constitutional right. It is something that the Constitution guarantees you. Yet to then say that you have a form of scrutiny under which it is constitutional for the state to say, but you can't exercise that right at all. There's really no other context in which a court would say, this is within the scope of the First Amendment, but you still can't do it. That's, to me, just a complete contradiction in basic principles of constitutional analysis.
I think,
Joseph.
Yeah, I think that it's important to clarify that there are no jurisdictions where public carrying is prohibited anymore. There was one state that had such a law, Illinois did. It was struck down by the Seventh Circuit in a case called Moore versus Madigan. Every state, the 42 which have shall issue regimes and the remaining 8, allow in some way for carrying of guns in public. So the question is, I think as Aaron put it, kind of how, whether fully or subject to different kinds of regulation, that right looks when you leave your home. Like the practical question is how the right extends outside the home, not whether it does, because in practice, every jurisdiction allows some form of it. And here I think that, my position is that government does have more leeway to regulate the public carrying of weapons than it does the private carrying of weapons. I think that's a natural implication of doctrine, of history, and of just common sense. Heller says that the interest in self-defense is most acute in the home. That doesn't mean it doesn't extend outside the home, but just logically, definitionally, it means it's less acute. That in the home, and this is again traditional self-defense doctrine will point to this, that's the person's castle where you have your strongest right to defend against an attacker. That makes perfect sense. That's, again, well established. But outside the home, if you take your gun into public, you're interacting more with other people and affecting their rights to feel and be safe from gun violence. The government's interest in regulation correspondingly goes up. Again, doesn't mean it can totally prohibit carrying of guns in public, and if a good cause restriction were to function like that, then it should be treated as such. But in practice, that is the way that I think the law has traditionally worked, and the law specifically with regard to guns. I mean, there is evidence of public carrying, as I've said, across the country. There is also evidence of much stronger regulation of guns in public than in private, and I think that makes sense. And it's not because self-defense needs don't ever arise in public. They do, and that's one reason I think why courts have either held or assumed that the right extends into public. But I think that to conflate the right to keep and bear arms, or the act of carrying arms, with the act of self-defense is, again, misleading. I mean, the vast majority of actions of self-defense do not involve guns. A recent study based on the National Crime Victimization Study found that less than 1% of self-defense actions involve guns. And the vast majority of gun bearing, of people exercising the right to keep and bear arms, fortunately, never involves self-defense. Another study, also out of Harvard, recently found that if every 3,500 households that keep a gun, only one in any given year will ever use that gun for self-defense. So there's an overlap. Guns and self-defense do sometimes overlap, but it's not as tight a connection as you might think from reading some of the opinions.
Well, thank you both, and thank you for your comments this morning.
Thank you, Bob.
And to the audience and to those who are listening around the country simultaneously, this is your chance to participate. So please get your questions up right away, and we are going to reconvene in 30 minutes. 30 minutes, okay? Thank you. All right, it's time for the participation round. You ready?
Absolutely.
Looking
Ready?
forward to it.
All right. The first question. Do you think that the 18th century writers of the Constitution would approve of this amendment's interpretation in relation to the mass shootings, powerful guns, suicides, and school shootings protecting gun rights in the 21st century? Who would like to go first?
I've already said a little bit of my view of interpreting the Second Amendment solely with regard to text, history, and tradition, so I don't want to recap that entirely, but I will emphasize that I do think the history matters. I think we can still learn from the history and the founders' views, and I think that they would not be antagonistic to most of the kinds of reasonable gun regulation that seem to be on the table today. Again, I think sometimes people are too quick to assume that history is antagonistic to gun regulation, as if gun regulation is a new invention, and it's really not. I mean, it's very hard to sort of project what the framers would have thought, could they have thought about the kinds of 3D printed guns and automatic weapons that they would not have been familiar with, or to think about school shootings. But we can think about what kind of general principles would they have endorsed or might they have endorsed, and I think that they might have been at that level of generality that would have permitted the government to address serious problems of health and death through regulation. They did not regard the right to keep and bear arms as being inviolate and being immune to regulation, and I think we're consistent with their vision if we see it the same way.
So I think that asking the question in terms of, what would the framers think today is a little bit of missing what the role of history is in how the courts think about interpreting the Constitution. I mean, the reason that the Supreme Court has talked about looking to history is not with the idea of, the framers were really smart guys, so whatever they thought or what we think they would think today is the way that we should think about issues or how we should think about the Constitution. The point of looking to history and to the text and to how it was understood at the time of the Constitution is to say, when the people ratified this amendment and put it in the Constitution, what was the scope of the right that they thought that they were putting in the Constitution to be a protected right? And start with that as kind of our background starting principle of, if the people thought it was important, understanding that firearms, yes, are dangerous, but also are important to self-defense, to put it that this was not just a right that you could trust the government to kind of regulate in reasonable ways, but was sufficiently fundamental and individual and important that it needed to be enumerated as the Second Amendment to our Constitution. That tells us something about, what is the scope of what we should be thinking about as the starting point for what is the baseline, the absolute minimum that the government has to allow. Now, none of that means that, you can't have debates about whether we still think today that aspects of the Constitution are what, we would make our Constitution today, but when we have a Constitution that enumerates rights, to kind of come in after the fact and say, well, if people knew then what they know today, would they have said the same thing? And if not, then we'll just kind of ignore what's in the Constitution, is an extremely problematic way of coming about constitutional interpretation and enforcing constitutional rights, because it essentially allows courts to kind of substitute their judgment for the judgment of the people when they ratified the Constitution and decided to put rights in there.
Well, when rights are identified by the Supreme Court that are not specifically enumerated in the Constitution, isn't what they're doing anyway?
Well, that's certainly a big criticism of many about the areas in which the court has found rights in the Constitution that aren't enumerated, and there's certainly a reasonable debate that we could have on many of those topics. But here what we're talking about is one of the enumerated rights. I mean, there's really no debate that the Second Amendment. I mean, you can have a debate about the meaning of the Second Amendment, but it's in the Constitution. The court didn't read the Due Process Clause and say we think that includes a right to carry firearms, even though there's nothing in the Constitution that speaks to firearms at all. So I really do think when you're dealing particularly with a right that is there, right there in the text, and historically, that there's this backdrop and this understanding among the states as well at the time of the founding that,
You have to treat that differently, and you can't just think about it as, oh, we're just in a realm, as with anything else, where whatever the government thinks is reasonable is good enough.
So here's a question to follow up on that. If whomever decides that the Second Amendment, as interpreted by the Supreme Court, is not what they want at this point, as a matter of procedure, can Congress change it, or does it require a constitutional amendment?
I think that's one we absolutely agree on.
I think, yeah,
Congress cannot change this. Congress is bound by the Second Amendment, just as are states and localities. That's the point of a constitutional amendment, is to say the only way that you could change it is through amending the Constitution itself, not through federal laws or through federal or state courts sort of pretending like the provision doesn't exist.
Yeah, we do agree, unfortunately, it's not something we can debate. To change constitutional law requires a constitutional amendment. Now, that said, constitutional change can happen, can sort of be driven by movements outside the courts, but they have to be ratified at some point by either a constitutional amendment or a constitutional holding of the judiciary. I would note, actually, here that the Second Amendment is an interesting example. As we've been talking about this 2008 decision, District of Columbia versus Heller, as really the first major Second Amendment holding by the Supreme Court. There are earlier ones, including a case from the 1930s called United States versus Miller. But for the first 2 centuries of the United States, there's not a single federal case anywhere in the United States that strikes down a law on Second Amendment grounds. It really was, as John said in his introductory remarks, effectively just constitutionally inert. Now, it's not alone. I mean, we've talked about the First Amendment. It's a very active neighbor. On the other side of the Second Amendment is the Third Amendment, which protects against the quartering of troops during your home in peacetime. I don't know how often any of you have ever invoked that right. I can tell you there's not a lot of litigation on it. The Supreme Court's actually cited it, but never really sort of opined on it. Sometimes constitutional rights constitutional provisions kind of do end up collecting dust. But in part, I think, as a result of a concerted effort, if you like, a social movement of gun rights advocates and scholars and judges and politicians, the popular interpretation and understanding of the Second Amendment changed. We don't have polling on this going back too far, but by the time Heller was decided in 2008, the core of the holding, the individual right to keep and bear arms, was quite popular. 75% of Americans said in 2008 that they agreed with it. I suspect, it's hard to know, again, because I don't have the polling data, I suspect that if you'd asked the same question earlier, even a few decades earlier, you would have gotten a different answer. And here we have more anecdotes than polling, so I can't say this for certain, but there are certainly voices left, right, and center. One that people often refer to as Warren Burger, Robert Bork, other people not known as sort of left-wing judges saying that the Second Amendment clearly did not protect an individual right. And again, today it does, and that is in part as a result of this sort of movement outside the courts. But again, to come back to my agreement with Aaron, Congress alone can't do it. Popular opinion and polls alone can't do it. It's got to lead to something that we recognize as constitutional change.
If I can just pick up on something Joseph was saying, I mean, I do think one of the reasons that you had this shift in thinking is in part to go back to what we were just talking about, which is in the same time we saw courts really shifting even more to this notion of interpreting the Constitution in a manner consistent with the historical scope of what the provisions of the Constitution were intended to protect when they were put into the Constitution. And it was really what a big part of the movement and the shift in thinking was that you started having a bunch of historical scholarship about the Second Amendment, and this really became more of, and there's other constitutional provisions that we've seen this as well in recent years, but as you start to have scholars really dig in on certain provisions, we saw similar things in the context of the Second Amendment with the Privileges and Immunities Clause, and once you start doing that scholarship in a very serious way, especially today when there's even greater access to a lot of the historical records, sometimes you can find things that are quite different than the way courts thought about things in the kind of period in the middle there where they just didn't focus a whole lot on the notion of kind of original meaning of the Constitution and thought about things from a little bit of a different interpretive process. So I do think that, some aspects of this are part of that. And I also, it's also worth noting, I mean, the whole kind of movement of enforcing constitutional rights at all is really kind of a 20th century thing. I mean, there were actually basically no First Amendment cases in the 1800s, and it just wasn't really kind of the way that most rights were litigated. So it's been an interesting evolution over really kind of the past century, having the courts much more involved in really expounding on the scope of all aspects of the Constitution, not just the Second or even just the First Amendment.
Joseph, you talked about how change can occur with the Constitution and how public opinion at least can play some role in that, although it's not dispositive, right? So I think a lot of lay people and lawyers would like to believe that the Supreme Court and that the courts, the judges, are just calling balls and strikes, that they're neutral, and they look at the Constitution and they neutrally try to evaluate what's in there. But we all know from following the television and the high coverage of the Supreme Court appointments, or the hearings and the non-hearings, that there seems to be politically a great deal of interest in who gets appointed to the court. So, as advocates, as people who have submitted briefs to the Supreme Court, when you submit those briefs, do you see yourself as submitting briefs to advocates who are wearing black robes, or do you see yourself as submitting your briefs to neutrals who are going to neutrally interpret what you say?
So I actually, call me Pollyanna-ish, but I actually, I really do believe, look, the justices disagree with each other because the justices have fundamentally different views about how to interpret the Constitution. And of course, if you have fundamentally different views about how to interpret the Constitution or how to interpret a statute or other, all the types of issues the courts deal with, you're going to come up with fundamentally different answers. And that's not the product necessarily. I think it's very easy to look at that and say, oh, it must just be completely results-driven and completely politically driven on both sides, and all they really care about is the outcome. But I think that misses part of, a good deal of what people are focused on when deciding, when looking at nominees and who's going to be on the court is not, hey, what have you said about whether you support a particular policy or particular law? You're not going to find many judges who've said many things about that because it's not typically what judges are doing. Most judges are not, don't have a background as a politician. It's focusing on things like, what is the mode of interpretation that you think is right for the Constitution? How do you think that we should evaluate? What levels of scrutiny should you use in evaluating laws? When you're looking at a statute, should you focus, purely on the text of the statute or look more broadly at purpose? Yes, absolutely. The way you think about those questions is going to have a huge impact on outcome. And I think what we've seen over time is, that by and large we have kind of a judiciary that's rather equally divided in having two very different approaches to those questions. So absolutely, when you're advocating, when I'm arguing cases, I know that there are people who come at it one way and people who come at it another, and that the way they come at it will, in many instances, kind of make it a foregone conclusion what they view as the right outcome in the case. But I do think that it's a mistake to think about that as, making the judges nothing more than kind of just politicians in black robes.
Yeah, I think I would separate the confirmation process, which I think in many ways has become just politicized in a way that's not helpful or useful to the development of an independent judiciary or the rule of law or people's understanding of what courts do, from the way that courts decide, as the way that judges decide or justices decide cases once they're on the bench, because it doesn't necessarily translate that an incredibly politicized confirmation process, and I agree with you, John, that that's become the norm, translates into a politicized judiciary. It may be the case that Justice Stevens, who of course just passed a few days ago, will be the last justice who's not interrogated on his views about Roe versus Wade or something like that, and seems to be evaluated solely on merit as a lawyer, and that's in many ways too bad. But there are also ways in which, judges and justices confound expectations. They don't always vote with the expectation or what you might predict based on the party of the president who nominated them. And actually, we can focus on the Second Amendment as an example of that. The 5 justices in the majority of Heller were all appointed by a Republican president, but so were 2 of the justices in the dissent. Some of the most prominent critics of Heller are stalwart conservative judges, people like Richard Posner, J. Harvey Wilkinson, Frank Easterbrook, kind of going against what you might expect to be the sort of party interest. That, to me, is a good sign. That signals that judges are taking their jobs seriously above and beyond the kind of, interests of the party that they might have the closest affiliation with. I think what Aaron said is exactly right, that judges and justices have, appetites and affinities for different kinds of arguments. And so to answer your question, John, when one files a brief, you would tailor the kinds of arguments to appeal to the justices and the judges whom you're trying to reach. And you mentioned earlier the brief that I filed along with two other scholars of Second Amendment law, Darrell Miller and Eric Rubin, in the New York case in which Aaron is representing the petitioners. We filed in support of neither side. We're neither defending the law nor arguing that it should be struck down. We did this work in the hope and expectation that the justices have an appetite for kind of understanding what we're trying to convey, which is what's the actual state of play of the law in the courts. I should also add, this is an area in which scholars, especially in the last 10 or 20 years, have done an enormous amount of work to actually measure, can you predict outcomes based on, for example, the party of a nominating president? And sometimes the answer is yes, and sometimes the answer is no. And here I should highlight some interesting work, and I should give them credit, by Adam Samaha and Roy Germano of NYU School of Law, who've done 2 studies recently on exactly the question of whether the various measures of partisanship and a judge's identity predict their votes in Second Amendment cases. And what they found in the first study was not very much. And in the second case, now that they've extended their time frame, in the last few years, they seem to pick up something. But it's not the case that, for example, all Republican-nominated judges are voting for gun rights claims and all Democratic-nominated judges are voting against, even in this particular area of especially broad partisan disagreement. And on that, I should say, again, judges are kind of outperforming politics as a whole. The political gap, the partisan gap on gun rights and gun regulation is huge and continues to widen. It's something more like 40 points or more now in the populace as a whole. The fact that we don't see that in the judiciary maybe is evidence that judges are doing something, again, as Aaron says, different than just politics.
Thank you. So this question is from Georgia, and there were others that were similar. Is there a balance to be made between the right to keep and bear arms versus the right to be safe from injury or death by firearms?
So, I think that thinking about it in terms of, a balance of one right against another is not, to me, kind of the way that I think you come about the issue. I mean, there's a right, and the right is to keep and bear arms, and it's protected in the Constitution, and as the Supreme Court said quite explicitly in Heller, we can't reconduct the balancing inquiry ourselves about whether this is a good and important right to be in the Constitution. That was the balance that was drawn by the framing generation and the people when they ratified the Constitution and put this amendment in the Constitution. So I don't think that you can, balance away the right in the sense of, well, yeah, it's here, but, this isn't a right that we really think should be fully protected because we're not sure we like it so much anymore. That said, obviously there is room, as there is with respect to any constitutional right, for some degree of regulation, and there can be, laws that can be passed that are animated genuinely by safety and by ensuring that people safely and effectively know how to use their firearms if they're going to need to use them for self-defense. And there's strong support on all sides of this debate for ensuring that people really do have, the training they need, that they ensure that they are actually, if you're going to have a firearm, that you are frequently practicing with it, making sure that your firearm is in working condition. All of these things are supported by everybody on both sides of these issues. And so I think there's absolutely room for having the right and having the right in a way that is protective of the ability of individuals to exercise it for self-defense, to have firearms for permissible purposes, while doing everything we can to ensure, of course, that firearms aren't finding their way into the hands of criminals and aren't being misused,
misused in ways that would cause injury or death.
Yeah, I agree with a lot of that. I mean, I think it is the nature of constitutional rights that occasionally they take off the table policies that might actually be quite popular or maybe even quite helpful. I mean, even if a handgun ban would save lives in the District of Columbia or in Chicago, the two major cities that had handgun bans before the Supreme Court struck them down, that's off the table now. The Constitution takes that off the table, even if it would save lives. So you can't just balance. The question, I think, and this is what I think Aaron and I have been talking and to some extent agreeing and maybe some extent disagreeing about, is the degree to which when you evaluate a particular gun law, short of a handgun ban, short of those kind of very stringent outlier laws, how much do you take into account and how do you take into account those savings of lives, those prevention of injury? And my argument, again, is that I think we should be cautious about taking that away from the political process when legislatures and executive branches across the country, both nationally, state, and local, are doing their best to find solutions. They can't exempt themselves from the Second Amendment, but I think they're trying to find solutions. I think the real question behind this question, in some respects, is what works? Like, what works and respects the Second Amendment? What are the gun laws that we could focus on that might actually get us there to reducing some of that 100,000 a year shooting number, that 30,000 or 40,000 a year death number, without going past these constitutional boundaries that we both agree exist. And there, I think there's still a lot of room for further research, further understanding. I mean, if we're too quick to take these kinds of policies off the table constitutionally, we may never know what works and what doesn't, right? This is part of the idea of the logic behind the laboratories of experimentation. Maybe handgun bans work, maybe they don't. Maybe restrictions on assault weapons bans work, maybe they don't. Wherever you are on the spectrum in the gun debate, I'll tell you there are plenty of studies to disappoint you. There are studies suggesting that the federal assault weapons ban didn't have very much of an impact when it was in force for 10 years. On the other hand, there is some good evidence that loosening of right-to-carry laws leads to an increase in certain kinds of violent crime. Those are hard questions that researchers and politicians and others hopefully are still grappling with. But I think we are in many places nowhere near the limits that the Constitution puts in, so we don't even have to answer this question. A favorite example of mine, I'll just put it out, is expanded background checks. This was the major push after the Sandy Hook massacre, was to expand the system of background checks. Now, the way background checks work is we have in federal law certain classes of people who are not permitted to possess guns. They're prohibited, either on the basis of a conviction for a felony, they've been adjudicated mentally ill, they're a fugitive from justice, they've committed certain domestic violence crimes, they're drug addicts. Those people are prohibited from having guns, from buying guns. How do you prohibit that from happening? We have a system of background checks such that sellers have to check against a list, is this person a convicted felon? Now that law, that system of background checks put into place by the Brady Act, went into force in 1998. Over the next 15 years, more than 2 million people were denied a sale because of a failed background check. Now, we don't know how many of those people would have gone on to commit gun crimes. I mean, that's speculative, but one can imagine if you think that those categories should be prohibited, that it might be a high number. Now, expanding background checks, would that come anywhere near the limits that the Second Amendment puts on? I don't think so at all. I mean, right now, the background check requirement only applies to federally licensed dealers, not people who are not federally licensed. They don't have to do background checks. So the proposal is to expand it. That's overwhelmingly popular. 80 to 90% of Americans say they support this. 74% of gun owners and NRA members. This is as close to a slam dunk as one gets in politics, especially in gun politics. But the people who are most opposed to it, and there is polling on this, give as their number one reason that expanded background checks would violate the right to keep and bear arms. And that's just a misunderstanding. That's not what constitutional law provides. So I guess the short version of my answer is that we are not, in most cases, yet near the limits that the Constitution puts into effect, so we don't actually have to engage in the balancing. We still have that space to figure out whether to fill, and that's a political question more than a constitutional question.
Thank you. Both of you have, in discussing that, raised the issue, I think, that comes up a lot when it relates to background checks or to gun possession in general, and that is the mental health issue and the intersection of mental health with gun possession. I'd like to ask you both to comment on where you think the intersection of those two issues lies.
I think it's a really important intersection and really important to understand, the importance of addressing both of those issues. I guess I'd just start by saying it's not an either or here. Sometimes it's presented as rather than address gun violence, we need to focus on mental illness, and that's not a choice we have to make. I mean, resources can and should be devoted, if they can be, to people suffering from acute mental illness or mental health problems, regardless of the impact that would have or not have on gun violence. But I think it's both underbroad and overbroad to focus on mental illness as if it is the problem. If we could do away with all mental illness-linked gun violence, we could do a lot to lower those numbers, the 100,000 shootings and the 30,000 deaths, but we'd still be left with an enormous public health calamity, right? The fact is that it's only a small percentage of gun violence that's committed by people suffering from acute mental illness. It tends to be the prominent ones. It's disproportionately in the mass shootings, the things that get the headlines. But that 30,000 number that I mentioned earlier of gun deaths is not coming from mass shootings. That's less than 1% of the gun deaths in the United States come from mass shootings. It's the daily drip of handgun violence and of suicides. And so any intervention that we can get there, I think, is really important. Now, keeping in mind that, again, mental illness is not a perfect proxy. It's actually a very poor proxy for whether a person is going to misuse a gun. The vast majority of people who've ever battled mental illness or had a mental health crisis are never going to misuse a gun against another person or against themselves. So it would certainly be too broad to say that anybody who's ever, sought treatment for depression or something like that should not ever have access to a gun. That would be wildly overbroad. The question is, how do we identify those people, those individuals who are really a risk to themselves or to others, and get to them at the time when they most need it? And there are various ways that law can do this, and one I'll just highlight because it's been one of the sort of regulatory innovations, if you like, especially over the last few years. More states have considered or adopted these laws. They're called Extreme Risk Protection Order laws, often called ERPOs or red flag laws. And the way these work is they're not, rather than being sort of a broad law that applies to everybody, an ERPO is a little more like a restraining order. So an immediate family member or a law enforcement officer can petition to have guns removed from a person who is a threat to him or herself or to others. A person who's going through a suicidal ideation period or who's threatening other people, who's lost someone and is in the sort of depths of a deep depression, someone who's worried about their father or their grandfather. Right? Those guns can be removed by law enforcement, and then a court hearing is set quickly so that the person can petition to have their guns returned to them. It's temporary, it's very targeted gun regulation of the kind that I think we can all, or at least consider as being the model for how this could work, especially at the intersection of mental health and gun violence.
Yeah, and I think this is a great area of an illustration of, there are certainly areas where, wherever you are on this debate, I think people are in agreement. I mean, I think it's common ground that everybody wants to keep firearms out of the hands of people who are mentally ill and would misuse them. I think it's also a classic illustration of how some of these things are often easier said than done. And I think that applies both in a predictive way and in a retrospective way. In a predictive way, we don't always know and don't always have a basis to know whether somebody is suffering from mental illness. And it can be very hard to draw that line and figure out whether, somebody genuinely is suffering from mental illness or is just kind of going through a rough patch. And it's very difficult when you want to try to craft laws that deal with that to figure out how to draw that line the right way. There's obviously things that are very easy to put on one side of the line, but it's probably, the gray area cases that are the tough ones and the tough areas in which to figure out how to legislate. And, when you look at some of these incidents of mass shootings where after the fact it's very clear someone was suffering from mental illness, it's not always abundantly clear that people knew beforehand the extent to which that was going on. And certainly in many of the instances, if anybody had, they would not have, they would have removed the firearms. I think there also, there can be challenges, as Joseph alluded to, on the back end. One of the rare cases that was some successful Second Amendment litigation involved an individual who was, well on many decades later into his adulthood, he had, around the age of 16, been hospitalized one night as a suicide risk, and that was then treated as a permanent bar forever for his lifetime, forever having being able to exercise his Second Amendment rights. And in an instance of what we consider an as-applied challenge, saying, you know, generally there's nothing wrong with a law saying that the mentally ill can't have firearms, but there can be particular applications of it that are problematic. That was an application that the courts agreed was problematic, to say that, you know, based on one incident during kind of adolescence, that somebody could forever lose their constitutional rights and essentially be branded permanently mentally ill. So I think this is a great illustration of how, you know, while it's easy to think of this as being these completely two polarizing sides, where there's one side that wants 100% regulation and the other side that wants absolutely no regulation at all, the reality is, you know, in the middle, there's just some issues that are difficult issues to figure out how to craft the law to actually achieve what, you know, the objectives that we do all agree are permissible objectives under the Second Amendment.
Thank you both. Another question, this one from Kentucky, and there were some similar questions asked. Is the individual right to bear arms that Heller has now identified limited to self-defense?
So I don't think it is. I mean, it's interesting, you know, Heller particularly, this is kind of going back to what I was talking about earlier, in the sense of it's very easy to kind of focus on the particular thing that Heller was focused on, and it was, you know, particularly focused, and there's quite a bit of language in the case that's dealing with the right to self-defense. And so absolutely, we do know from Heller that the Second Amendment includes and protects the right to keep and bear arms for self-defense, but there's also quite a bit of discussion in Heller of other permissible uses of firearms that have long been accepted, including particularly, you know, that they have long been used for hunting purposes, going back, that was probably, you know, the more frequent actual use of the firearms that was happening back in the founding days was that people possessed them for hunting. And certainly, I mean, there's many cases that, notwithstanding what the court kind of intimated in our own case that's going up to the Supreme Court right now, there are courts that have recognized that the right includes, you know, the right just to have proficiency with your firearm, to use firearms in competitions, and all sorts of permissible uses like that. So, you know, I think they've been a little bit less explored in the cases because there tends to be more protection for hunting, and more of the restrictions that we've seen come in the nature of, you know, in the home and carrying, which are more what we think of as self-defense uses. So they think there's been a lot more attention by the courts paid to the scope of the right as a right for self-defense. But certainly as a historical matter, and certainly if you focus on Heller's analysis historically, you know, the right is not strictly confined to use for self-defense.
Yeah, I think the court in Heller, and then 2 years later in its opinion in McDonald, says that self-defense is the core, and I think the central component is the phrase that the court uses of the right to keep and bear arms, but that doesn't mean that that's the only thing it can include. Sometimes rights, even within them, have certain parts that courts treat more sensitively than others. Political speech in the First Amendment context is an example. Gets a whole lot of protection. Commercial speech covered by the First Amendment, but gets a little less. You might see the same kind of, you know, peaks and valleys within the Second Amendment, and I think self-defense, again, especially in the home, will always be the peak. What Aaron was saying about hunting reminded me that we haven't yet mentioned state constitutional law. We've been talking just about the federal constitution, but actually a lot of these questions are addressed and sometimes answered by state constitutions. And prior to the court's decision in 2008 in Heller, there was a lot of litigation throughout 2 centuries under state constitutional provisions, which in one way or another protected a right to keep and bear arms. There's been recently a move to amend state constitutions in some places to specifically protect the right to hunt. You know, whether the right to hunt alone would be, you know, considered the same kind of core as self-defense is to me at least not quite as convincing. But that doesn't mean it's not part of the Second Amendment right. It could be sort of on the fringes, on the penumbra, sometimes in the shadows, as we say. I think it's also interesting to note that what Aaron said, I think, is exactly right, that hunting and recreation were probably the most common uses for guns in the late 1700s. In fact, that was true in this country until just a few years ago, that hunting and recreation were the primary reasons that gun owners gave, the most prominent reasons gun owners gave, according to polls, for why they owned their guns. And it wasn't until, I think 2013 was the first poll that showed self-defense has now become the most common reason for gun ownership. So that is a very recent development, and it may have to do with the fact that hunting as a pastime is becoming less popular. Gun ownership, the number of guns continues to go up, but gun ownership continues to decline by most measures. About a quarter of individuals today say they own guns, which translates to about 35% of households. So these changes or these sort of, stakes in constitutional law may map onto sort of different ways in which people are thinking about their weapons and what they're useful for. There are others who will say, and there's a strain of this also in certainly Second Amendment rhetoric, if not entirely in case law, that the reason that people should own guns is not for self-defense against criminals in the home or for recreation and hunting, but to prevent tyranny, to prevent the rise or deter the rise of a tyrannical government, which is a thread which is, I think, at least in political discussion, sometimes quite prominent. I don't think you yet see many courts deciding cases on that basis. It's a hard principle to
There was one,
case law. There was one, and and I should say, I don't want to sound as if I'm entirely mocking this proposition. I mean, the view of the amendment that the court rejected in Heller, that is the view advocated by the dissenting justices, was in some form an anti-tyranny view of the Second Amendment. The view was that the Second Amendment was put in place to protect the state militias from disarmament by the federal government. The thought being that at the time the amendment was passed, the new federal government, with its vastly expanded powers, with the existence of a standing army, was seen by many as an existential threat. And the thought was, well, we'll protect the state militias from disarmament as a check against that federal power. That is in some ways an anti-tyranny view. It's not individuals choosing for themselves when tyranny has come about and when they should rise up. It's mediated through the state militia. But the notion of using guns against a tyrannical government has at least some pedigree, although again, that was a pedigree that the court rejected. It's harder to make it work, I think, through an individual rights frame. But it does happen.
Well, and there certainly is, while the court has made clear that there is a core right under the Second Amendment to possess and keep and bear arms for self-defense, that's not to say that you ignore that part of the amendment is also that it was an amendment that is, part of it is about ensuring the preservation of the militia. And from that perspective, one of the core and critical aspects of the Second Amendment was people would own and keep and bear arms so that they would actually be proficient in their use if called to militia service. And when you think about that as part of the right, which, it just unquestionably is historically part of the right, it speaks a lot to the uses to which people should be able lawfully to put firearms. Again, I go back to, it certainly has to be the case that there is a right to gain proficiency in the use of your firearm, because the whole Second Amendment would kind of make no sense if the idea were, why don't you possess some firearms that you can have for self-defense and that you could be called to use in militia service, but we don't care if you have any idea what to do with them when you show up, So it's certainly, an important part, and I think that when you think about that, hunting and target practice and all of those things, without them, the aspects of the right that are most important would kind of be meaningless for people to try to exercise.
Going back to the question about the amendment and amending the amendment, I should have asked this at the time, but we have had a question about whether or not there have been any attempts to amend the Second Amendment.
I don't think there's been, there's certainly people who talk about it, it's been proposed, but it has not, the Second Amendment is widely supported still by people, and really there is not public support for an amendment, and I'm not sure anyone has actually even in any real way proposed one beyond proposing it in sort of the abstract for public debate, so it really is still, notwithstanding the fact that, there are certain quarters that certainly don't like that we have a Second Amendment, that the American people, by and large, feel very strongly about keeping the amendment, and I think that's why the movement really has not gained any kind of public traction when raised by the couple of folks that have kind of put the idea forward.
Yeah, I agree with that. I'm not aware of any major effort to repeal the Second Amendment, or for that matter, overturn Heller. These are even among sort of gun violence prevention groups. One doesn't see this as a major talking point. It doesn't seem to be a partisan divide. The day Heller was decided was during the lead up to the McCain-Obama election, and both candidates came out and said they supported the individual right to keep and bear arms. Again, I said this before, but 75% of the American people say they support the individual right to keep and bear arms. Support for what you might think of as the most stringent gun regulations, like bans on handguns, have never, with the possible exception of one outlier poll in the 1950s, commanded a majority of support. Like the American people are squarely on the side of the individual right to keep and bear arms, meaning something. Now, that doesn't mean they agree about what it means. And again, I think that's part of the discussion that we've been having today. And again, this is where I'll just point out again, because I think it's just such an important fact, that a majority of Americans support what they understand the individual right to keep and bear arms to be. Even larger majorities support things like expanded background checks. That means there is a big overlap of people who believe both in the individual right to keep and bear arms and that it can constitutionally be regulated further than we have. And I think that's right. I think that's where the constitutional law is. And sometimes it's hard to hear or see that kind of overlap or that area of agreement because the extreme voices kind of drown out everybody else with the sort of with screeching. But there is actually a big middle, if you like, here, which constitutes both where the law is and where I think most Americans are, which is, yes, constitutional right, we can live with that. We can live with Heller. And also, we could do a little more to expand the regulatory space that it leaves, like things like expanded background checks, extreme risk protection orders, maybe some more targeted laws focusing on at-risk classes of people or classes of arms. And that, again, should be sort of shy of the constitutional litigation, I think.
Yeah. I mean, the one slight addendum I would put to that is, I'm not sure that everybody would agree with the proposition of, there should be more regulation than there is. I think that there's certainly, there are regulations that some jurisdictions don't have that I think there's broad agreement that are fine regulations and that jurisdictions should have. I also think there are a great number, there are many regulations that many people do not think are constitutional, and so to me, there absolutely is overlap about the issue of there are ways that you can have regulation that is consistent with the Second Amendment, and some of those may be regulations that are not on the books today. On the flip side, I think there's a lot of debate about some of the regulations that are on the books, so I think that we have a right that part of the debate, and I think part of the policy debate is, are the regulations that are being passed ones that make any sense, or are we kind of doing things that sound like they're responsive and have a bit of a feel-good nature to them, or have, you slap some pejorative labels on certain types of firearms or ammunition and it sounds like you're going after something, whereas there may be other much more targeted types of restrictions and regulations that actually could achieve much more but don't get quite as much play because they just, don't kind of capture some of the politics of the issue.
Yeah, the theme, I agree with that emphatically, and we just want to sort of amplify what Aaron just said, is that in some ways we have a lot of different gun debates, and the question shouldn't be, do you support gun control or gun regulation in the abstract? The question should be, do you support particular kinds of policies? And you get different answers when you ask those questions. Some people will say, no, I don't support gun regulation, but then you ask, well, do you support background checks? Yes, I do. Or if you ask people, should we, do you support gun regulation? No, we should enforce the laws that we have on the books. Then if you ask people what laws we have on the books, turns out people wildly overestimate how much regulation there actually is. People tend to assume maybe that we've got, for example, a federal ban on assault weapons, which we don't. So I think the way to approach the issue, I think, is exactly as Aaron suggested, is focus on particular questions, particular policies, whether it's background checks, whether it's assault weapons, however you define it, whether it's high-capacity magazines, whether it's bans on particular groups of people. Like, those are the kinds of questions we have to be asking, not the broad, are you for or against the Second Amendment question.
So let me use the moderator's prerogative and ask you the last question. And this question is, if you had been sitting here 12 years ago, you would have been arguing whether or not there was an individual right under the Second Amendment to keep and bear arms. We're not here debating that anymore. So if you sit here 12 years from now, what do you think you will be debating with respect to the Second Amendment?
Well, 12 years from now, let's see.
Well, first, I hope we are back here. This has been a lot of fun, and I'd certainly like to run it back. I hope you'll all join us. I think my guess is that we will still be working through the implications of District of Columbia versus Heller's holding and what it means to have an individual right to keep and bear arms. I think that that's still going to be the framework. I think we're still going to be, in some ways, addressing these sort of brand new questions, which, frankly, for a constitutional scholar or a constitutional litigator, is about as exciting and challenging as it gets. I mean, this is, Aaron said earlier, and this is totally right, that even the First Amendment was not a particularly active site of constitutional litigation until about a century ago. In fact, exactly a century ago when Justice Holmes wrote his major opinion in the Abrams case. There really wasn't a lot of law. But if you'd been on the ground for those first few years, you would have been seeing the sort of nativity, the growth of a brand new constitutional right. We're still in the very early stages of figuring out even basic questions of the Second Amendment, like its scope. Those questions are not as prominent anymore, I think, for the First Amendment, because we have a century of case law and just reams of scholarship and books and articles, and the Second Amendment is just catching up. Judge Wilkinson described it in a case a few years ago as terra incognita, and that's still relatively true. So I think we could have the same conversation with maybe some of the same questions, but if not, a new set of questions, whether it's 3D printed guns or some new kind of smart gun technology. The market's always changing, the problems are always changing, the regulations are trying to catch up, and then the Constitution is sort of there in the background. Yeah, I look forward to it. Let's do it again, 12 years.
Sounds good to me. Yeah, one of the reasons that when we talked about what we were going to kind of talk about and debate today, didn't really want to just kind of debate the question of whether Heller was right, is because it is the real issues that people are struggling with are not really that. It's this question of what do we do with it? What does it mean? How do we determine what are the right regulations that are consistent with the amendment and those that aren't? And I don't, I think those questions will go on, not just because they're tricky in this area, but because those are the debates you see in really every area of constitutional law. That's always the challenge when you're dealing with a constitutional right, to determine, what does that mean? How absolute is a right? How do we determine the role of the government in its ability to regulate in the area of rights, and the role of the courts in reviewing the regulations that the government passes? So, those are really foundational questions about how you think about the law, and I don't think they will go away anytime soon. I do think that probably the next kind of big issue that the Supreme Court will resolve in the next few years, hopefully, because it is an issue that has divided the lower courts, is whether the Second Amendment encompasses a right to carry a firearm outside the home. That is probably kind of the issue on which, kind of the biggest nationwide issue, nationwide impact on which the lower courts are divided right now. And at some point, the Supreme Court, they've so far avoided it, but at some point they're going to have to step in and answer that question, because it really is an instance of disuniformity across the country.
Well, we have all been here today exercising our First Amendment rights, and we understand the importance of the Constitution and the importance of this amendment that we've been discussing today. I'd like to thank Osher for making this First Amendment discussion possible, and I'd also like to thank our world-class experts who have taken the time to come up here and share their thoughts with us. Thank you both so much for being here.
And thanks to you too, John.